Hello, I'm Laura Furiosi, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years' experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom. How do you deal with lump sums in property settlement? Is it really fair if you get an inheritance from a passed on parent or family member and then half of it ends up having to go to your ex in a property settlement? Well, today we are going to be talking about all sorts of lump sums that can happen in property settlement, from inheritance to personal injuries claims, redundancy payments, long service leave and bonuses, and how the court looks at it and how you should try and deal with it if you're going to mediation or trying to just settle your property with your ex. Welcome, Mum.
Hello, Laura. That's a lot to get through. Hello, everyone.
And look, the reason we're doing this episode is because we've realised there is a lot of people out there who have been asking these questions of late, haven't they?
Yes.
Whether they've, as we get older, our parents pass away at some point. Mum, you're not going to be doing that anytime soon. But you get like an inheritance, and imagine the feeling you would get of having to then give half of it to your ex, or a personal injuries claim, maybe someone slipped over and broken a hip, or, so there's a lot of things that can happen in that stage of just before divorce or during divorce. So today we really want to go into that to alleviate anybody's worries about what we should do. And Mum, I know you've done some research today and you looked up some cases. So we're going to be talking about cases as well. But you don't have to be going to court to listen to this episode. It can give you a good indication, can't it, Mum, of what is to be expected.
For settling, yes. And I guess the first issue I'd probably take with what you said, Laura, was that it's not always half. It was funny. I did the research just to see if there's any recent cases on these things, and I came up with 1985, 1991, and the most recent case I think is about 2013. So the law is pretty settled about lump sums, but because people come into a divorce and they've never thought about it before, it's a new thing for them and they want to know how it's treated. So,
we're not reading the news when a new case comes out that draws some new law on inheritance.
Yes, nothing new comes.
No one pays attention to that sort of stuff.
No.
So that's why if you're in that boat, you're here today. Listen, and Mum's brains and her knowledge will hopefully give you some comfort. So, Mum, let's just go through them one at a time maybe, and let's start with inheritances.
Yeah.
And you said there's 3 different phases of the way they deal with them. Did you want to talk about that at all?
Yeah, so I think that was the best way to explain them. So the court treats inheritances differently depending on if they've been received early in the marriage, late in the marriage, or after the marriage. When I say marriage, I mean de facto relationship as well. So, so during, after, and late in the marriage. So it's 2 times in the relationship. If it was received before you guys got together, then that's a contribution on your behalf. That's quite clearly decided. But it does get tricky. If you get, say, $200,000 a year into a 15-year marriage, then you can't expect to come out the other end with your $200,000 intact or creamed off the top. Sometimes people do reach arrangements like that, but they have to put them in a financial agreement because that's not how the court looks at it.
So what you're saying is if you get the inheritance and you get it while you're married and then you are continually being married for a long time,
yes,
it's really hard to kind of tease that out and make that money that I got 20 years ago is mine.
Absolutely. So what the court does is treats that as a contribution on your behalf, but it may not be to that full extent. It might be in percentages. They might give you an extra 5, 10%, depending on what proportion of the property pool the settlement was. So if all you've got at the end of your 20-year marriage is $400,000 and $200,000 of that came from a family member as an inheritance in the beginning, then you would be regarded as having quite a big contribution, and the court would, you wouldn't get 200 plus half the remaining 200, but you would get, like, possibly thinking figures here, depending on other factors, maybe 70% of the property pool or something on contributions.
Yeah. And remembering this is just education.
Education.
This isn't a legal advice because mum doesn't know anybody's situations, but we're just giving you an understanding of kind of where the case law is at the time. Okay, so mum, so what happens if they're separated and they get an inheritance?
Yes.
But they're not divorced yet.
Okay, so separated getting an inheritance is the same as getting an inheritance really late in the relationship. If you haven't had your property settlement and you're getting and then there's an inheritance coming along, that's going to be treated as usually part of the property pool. I have heard of cases where they can quarantine the inheritance and say, look, the reason we're just going to put this to one side and make it a second pool because the other person can't be said to have made any contribution to it. Usually then late in the relationship, after separation or just in the, leading up to separation, then it's seldom that the court will find the other person made any contribution to it. So it may actually be able to be quarantined or put over as yours for the future. But then the court says, okay, you've got that up your sleeve. So the rest of the property, we need to give more to the other person because they don't have that resource available to them. So it's kind of catch can in a way.
And another question that seems to pop up a lot, Mum, is what if there's an inheritance coming and someone is their I don't know, their father is 110 years old and he's a millionaire and they know that he's going to be passing that money on to his son. What happens then? Because, I mean, it's a bit macabre. It's a bit horrible to be doing a property settlement based on something for someone who's not even passed away yet. But what happens then?
Well, the court is not interested, okay?
Okay, good.
It might crop up, someone might drop a throwaway line that they stand to inherit money. But as long as that 103-year-old dad still has the capacity to make another will, then it's not guaranteed, it's not in the bag. And there have been cases where the parties have tried to get the other person's parents' wills into evidence, and the court finds that very distasteful. They really have to, because what they say is, who knows, you might have a falling out with that person and that 103-year-old man might change his will. So it's just kind of there in the ether, but it doesn't come into it as a factor in property settlement. That is that person's good fortune. It's where they were born in life.
So if anyone's dealing with inheritances as an issue in their separation and property settlement at the moment, are there any cases that you can point them to have a read if they want to be a legal person? Yeah.
I think, though, can I just say, I think anyone who's got an inheritance floating around, whether it's just still in probate or whatever, you need to go and get independent legal advice on this and find out exactly what applies in your case. But for interest's sake, look up Bonici, Bonnici. That's a 1991 case. And the court said in that case, they said that if there's enough other property to do justice between the parties, say in our example, for instance, if you've got a $200,000 inheritance sitting over there, there's $400 worth of property to divide between you both, then your ex-partner could get a bigger share of that $400,000, and that would be adequate compensation in the eyes of the court. However, what if that $200,000 inheritance is all the money there is? Now, we're assuming you've got it, right? And it doesn't matter when you got it, before, during, or after. If that's all there is, there's hardly anything else, then notwithstanding that there's no contribution made by the other person, the court will dig into that inheritance and give some to the other party on the basis of future needs. So Bonici is authority for that. If justice can be done from the other assets, have a look at paragraph 42. Anyone who's diligent enough to read it, then they'll leave it to one side.
We'll put the link in the show. The link in the show notes.
And then in Bishop 2013, they agreed to quarantine it, but I think they got away with that because the other person didn't want a share of it. They all agreed to just put it to one side.
Well, and I think that has to be considered just because that's what the court does. If you manage to have an ex and it's amicable-ish, or, they respected your parents, and if they've passed, they respect their wishes to pass that on to you, you can sort that out between yourselves and have your property settlement, consent orders, a financial agreement, whatever, and not involve the court too much in that. So, because it does feel so unfair that if someone's ex has passed away, your ex's parents have passed away, that you somehow end up getting some of it. But I guess if that's all there is, then you do need
That's different. And I mean, I think that a lot of people have the decency not to want part of their other person's family's money. And also, I often ask my clients, well, what about your folks? Are they well off? What's happening there? Because although it's not an offset exercise really, it helps my clients understand why they might not be entitled to exactly half or whatever of the inheritance that person is getting.
All right. Well, then let's get on to the next one. Personal injuries claims. Now, these are... I know you're not a personal injuries lawyer, Mum. You don't chase ambulances. I'd have to tell you, when I was in Las Vegas for a baby trade show, long story, but there were these billboards for lawyers that were hilarious about personal injuries. They must have different laws over there for lawyers and advertising, but it made me laugh. They look so shoddy, like little sharks trying to get your money. I guess personal injury claims, people could slip over on a grape at McDonald's, not at McDonald's, but a grape at Woolworths and, get paid out big dollars. So what happens with personal injury claims?
Well, again, the problem is with personal injury claims, were they received early in the relationship, were they received later, were they received after, even are they potential claims? So the court has quite a job to do if anyone asks them to deal with these. So first thing to know is that they're in. The personal injury payment is a thing. You don't ignore it. It's there.
Okay.
Usually, if it's a severe injury and there's a lot of money involved, there may be what's called, well, in Queensland at least, a Griffiths and Kirkmeyer claim. There may be a claim that that case says that the other person had to do more. The other person in the marriage had to nurse you and do other things because you were injured, and part of the property settlement component will be for that other person. So the courts started to look into the components of a personal injuries claim, but they don't anymore. They just say, look, it's in. And if you've got an ongoing injury and need ongoing care, then that, of course, will be reflected in your future needs factors in 75 too.
Which we've got an episode on. You can listen to that, Future Needs. Or if you're a member of our DIY Divorce Blueprint, you can actually do the whole lesson and figure that out down with a little worksheet. Okay, so if you need future needs, then some of that personal injuries claims, of course, is going to go to you because you need it.
But
what
else? Part of the whole thing. It's as part of the whole thing.
Right, so they include it.
Yeah. Sometimes a person gets an injuries claim and they are able to rebuild their careers and they're working again, and that matters. So because another component of a personal injuries claim is your economic loss going forward. So say you were a tree lopper, physically working out, you hurt yourself, you hurt your back, but then you do some study and you're now a very good computer programmer and you're making more money or the same money. So that money that would have been for your future economic loss doesn't need to come to you. It can stay in the property pool to be divided. But if as a result of your injury, you can't ever work again, you can't build up your money again, then that gives you a greater share under your future needs factors of the whole property pool. And that way, whilst the personal injuries claim doesn't sort of remain in a little capsule in the property pool and treated separately, it blends in with everything else. But it does kind of all come out in the wash. The court tries to do justice between the parties financially without sort of being rigid about saying, well, this was for this person. Okay.
Basically, what you're saying is if there is a personal injuries claim, then it is included. It's not quarantined away separately like inheritances can be. But what if they haven't claimed it yet, but they can?
Yes. So there's a French saying called shows in action, CHOSES in action, and shows means things. And I think we still use the jolly expression in some of our documents still. But so that means you've got the right to sue, you've got potential, you might have even started application personal injuries claim, but it hasn't quantified yet. Sometimes people have to wait for their injuries to settle and it can be years. It's just something that it needs to be disclosed to the other person, and it's just really noted as a future resource. Generally, if you've been injured, the court leaves that because it will compensate you for your injury claim. If you're still waiting, then the injury probably happened close to the end of the relationship, and it may well be something you get. But make sure you disclose it in your material. If you don't tell the other person about it, and you later on get a lump sum and one of the kids blabs or a neighbour or a friend tells them, then that's grounds for overturning your property settlement. So put it in.
So you have to be honest.
Always, please. And just a note there, Laura, as you said, I'm not a personal injuries lawyer, but there are timelines. I know there are absolutely brutal deadlines and timelines with personal injuries claims. So if any of our listeners have got anything that they think might be a claim, run, don't walk, run to the phone and ring that lawyer and get a first appointment, because I think some of the notifications have to be done very early on in the injury.
And there's a lot of no win, no fee lawyers for personal injuries, isn't there? So
don't start.
I wish that was a family law one. No win, no fee. Imagine that.
I don't know if anyone, I mean, I know that there was some issues about them advertising that. I think it was heading down the American route. I saw a billboard in Florida once, and it was where were we? Las Vegas, and it had a big sign up, and it was something Rodriguez, the original half-price lawyer.
That's not what you'd want to be known as. Oh, dear. Okay, so personal injuries claims, as sucky as it is, they're going to be included.
Yep.
We did have someone ask just recently, should I delay it? But like what you're saying is definitely disclose that you can claim it or you're thinking of claiming it. And then anything that happens after property settlement, once it's finalised, is yours. So that's another good reason to make sure you settle your property, because I know some people, which is great, they manage to sort it all out themselves. They don't involve the courts. They just go, you take this car, I'll take this, and walk off together separately. But what happens if someone gets hit by a truck and they end up with, like a $500,000 payout? Or I know someone recently that's got like a $3 million payout. They then technically could go back and ask for some of it.
Absolutely. So if you remember, I talked about the case of Farmer and Bramley. You probably don't, because they're the same names over and over again. But in Farmer and Bramley, there was a relationship there. We can put the links in here. It was a long marriage, 4 kids. They had nothing. I think their father had some drug problems, and the woman was left with the kids and nothing. And then, as luck would have it, I think 18 months later, maybe, after they split up and they decided it wasn't worth putting it down in documents because it was just kitchen furniture and a couple of beds, he won $5 million on the pool.
Oh, dear.
And he originally tried to say it was his mother's, but it was his.
Oh, no.
I think he got more punished because of that. Her lawyer went to court and said, even though he got that completely after separation, you can't ignore the contributions my clients made with the children and putting up with him and long years together. And the court gave her, I think it was $795,000 out of it. And because the court says it doesn't have to have occurred, the contributions don't have to have occurred at the same time as the receiving the income, or the other way around. So that tells you if you do just say, look, don't touch our supers, we'll keep our car, and walk into the sunset without getting something finalised with a stamp or a proper agreement, then these things are open to try.
So basically what you're saying is be careful, you might win the lotto or you might end up hurting yourself and getting a big payout. So that sounds like two things, that one thing you would want to happen and one thing you wouldn't want to happen, but both of them you don't want to happen until you've got your property sorted. Okay, let's go on to the next big one, Mum. Redundancy payments.
They're tricky, aren't they? Any bonuses and redundancies and things. So what the court says about a redundancy in the cases is this. A redundancy payment is to tide you over till you get another job or retrain or whatever you need to do, okay? If, in fact, you walk straight into a different job, then that's a bonus, isn't it, that money? And that then is a contribution on your behalf, but it's still a contribution to the family nevertheless. If, on the other hand, you get a bonus or get a redundancy, and say it's after you've separated, and you say, well, I'm going to use that time to go to uni, to regroup, to get over my grief of losing my job, and you don't work for a certain period of time and use your redundancy to live on, then that is not counted as property. So redundancy pays, and we'll talk about long service and things like that. It all depends what you do with them, whether they're counted as money or not. But if they're just sitting in a bank, then they're in the property pool and they get divided. If you've put it into the house and put a pool in or an extension on, then it counts as part of the house. And the fact that your redundancy came in is not really a contribution by you, because normally you would say that redundancy came about as a result of the work you did, which you did during the relationship. So the money that came in as a redundancy is also something from the relationship. So you both really contributed to it, unless it's well after separation and you didn't have the job to start with when you separated.
All right. So redundancy payments, long service leave, bonuses, they all kind of all included in that thing, or a bonus is different?
Yeah, bonuses are different. Yeah. So long service leave is a bit like a redundancy. If you say, I've got 13 weeks long service leave and I'm going around Australia with that money, then the court will not count that as a lump sum. It's your living expenses. You're entitled to your long service. Bonuses, on the other hand, bonuses. So a lot of people get bonuses in their jobs.
Hang on. Can I just ask one question about long service leave? So if you choose to use your long service leave to go on a holiday,
yes,
and have a break,
yes,
what if you choose to use it to buy a house
well, that's in the pool
and go straight into another job? Oh, then it goes into the pool.
Yeah.
Okay.
Or even if you use it to buy a house and live on potatoes or go to your mum's for the 13 weeks or whatever. Yeah, it depends what you do with it. That's what I'm saying. It depends what you do with it, with redundancy and long service.
Right. Okay. All right. So what about bonuses?
Bonuses, as I said, are a little bit of a fraught area. So people sometimes get bonuses based on performance or based on the company's performances. That's a contribution by you, okay? And if you spend it, though, it's a contribution by you to the property pool if it's during the relationship. And if you spend it, then that's a premature distribution of assets, because bonuses come in lump sums. And it's not to allow you to go on holidays, and it's not to allow you to have a break or to find another job. It's just a bonus. It's just additional income that comes in a lump sum.
Okay. So if your ex gets a bonus and you haven't property settled yet, then that bonus goes in the property pool.
That's right. Yep.
Right. And there's nothing you can really do with the bonus that's going to be like with long service leave, go on your holiday, or personal injury claim, use it for medical expenses in future.
Yeah.
Okay. Right.
But it's really just wages. It's just deferred wages.
I know we've kind of talked about early, late and after all of those phases. What if you get a personal injuries claim or an inheritance or redundancy before you get married, before you end up in a de facto relationship?
Okay. So, that'll be money. And it will be your contribution to the relationship, no matter where it came from.
Okay.
So, you just would prove that with bank statements and things. And so that's what I had at the beginning, was from when I injured my leg or whatever. Yeah.
And you can listen to our before property settlement episode where we talk about all the things that they look at in the before. We talk about before, during and after and future.
Cohabitation. Yeah. Cohabitation.
Oh, that's right. That's that word. Gosh, that's a yucky
living
word.
Together. Yes.
Ooh, let's go cohabitate together. So, Mum, my next question for you is, have you seen anybody use any tricks or try and outplay court with these inheritances, personal injury claims, redundancies, long service leaves or bonuses?
Oh, really? Yes. The common one is the inheritance. People like to stall on that inheritance and say, oh, it's nothing's settled yet. I don't know how much it'll be. But then you find that they're actually telling the person who's doing the executor of the will to go slow, go slow, go slow. That won't help them, because you can have a wild guess at what it's going to be. You can subpoena the executor and ask how much money there is and put that in as a potential income from you. As for bonuses, yes, I've seen people on the other side ask for their bonuses to be deferred and not paid until after separation. I know one man who got, $50,000. It wasn't my case. He'd just been holding it, just hadn't issued bills from the business. In Weir's case, which I talk about, that's the quarry case, there was like $134,000 worth of gravel missing, but no receipts, no bills for it, no nothing. Either that person had set up a spare one, like another account and hidden it, or he'd said to all his mates, which I think is what happened, don't pay me yet. I'll issue you a bill after this is over. Personal injuries claims, yes, again, they can be go slow. Same with claiming pensions, military pensions. I don't want to claim this until after my family law matter's over.
So have you found that if it does end up in court and these kind of tricks get exposed, that what might have happened is more extreme, is it in a form of a punishment to the people that have done the wrong thing?
Yeah. Yeah, absolutely, because the full court said that the court should not be unduly bothered about punishing a person who has tried a sneaky trick and made, hasn't made proper disclosure. So the court always has a range. There's no like one right answer. There's a high and a low range, and I'm sure that conduct of the parties or how they appear in the witness box can help make the judge lean more one way or another. And that was what the full court said in Weir's case, that we should not be unduly troubled by, allocating extra to that person or to the person who's had the wrong thing done by them.
Have you seen cases where they've had property settlement and then someone's been able to bring them back later because they've found that they've hidden it?
In my own personal career, I've seen one where they tried, but it turned out it had been disclosed. It was in the document. I did have one case once where the person, they came out of court and he put up a picture of a big sailing boat on his Facebook and said, "Look at my new boat."
Wow.
But a few urgent emails and a couple of threats later, it turned out he'd just done it to annoy her. But yeah, wow. I mean, I'm sure people do. In my career, I've seen money being sent overseas into betting shops, online betting shops, or off to rallies overseas. People just can show their quite sneaky side. What's
the best advice, general education you can give to someone who's listening, who's worried that might be what their ex is going to do? How do you make sure that it's fair and that the other side is doing what's fair?
You can't be sure. What you can do, though, is you'll notice when you do an application for consent orders, you put in your information and you only swear to the truth of your side. The other side has their information, unless we've got an avoided person, in which case you've probably filled it in for them. But they sign to say that's a true reflection of their situation. And that way you've got them on oath saying this is all I've got. If subsequently something turns up, you can go back to the court and overturn those orders on the basis of non-disclosure or fraud. So that's why they have to sign things when they put their applications in. That's why they have to swear to, if you're in a court, you have to swear that you've given full disclosure and an undertaking about that as well. So, yeah, that's your protection.
Okay. And I guess...
Otherwise we'd never finish sometimes because you've got some dodgy people on the other side. So you kind of do the best you can and then keep your eyes open in case there's something else revealed.
And if you want to know how to do consent orders, we talk you through step by step in our course. We'd walk you through how to fill in the form, how to do it all. So you can check out the DIY Divorce Blueprint. We're not open at the moment, but we will probably open again in the future. So you can go on our wait list and email us at thedivorcecoursepodcast@gmail.com to go on that wait list, or send us an email to say g'day either. So, Mum, my next question to you is, so that's what the court thinks, and that's the court's attitude. A lot of our people, and we know this, a lot of people don't end up at a trial, they end up at mediation or negotiating with legal letters. So if our listeners today are going to mediation or they're negotiating in letters and writing, can they use this knowledge and information in their mediations?
Yes, and if you have to take the cases along, print them out or have them on your phone. But yes, of course, because everything that we talk about that the courts say and do, that becomes your guiding light at mediation, because you're comparing what you can get at mediation with what the court is likely to do, and it might be that you are wanting something that can't be achieved, that the court can't give you, that this person, if they've got rich rallies and so forth, it might be useful for you to know that the court's not going to fix you up for that. Or if you can't track all the dollars that they took during the marriage, the court might not take that as well. So everything in the course can be used in mediation. Everything in these podcasts can be used to help you in mediation, helping you to settle, as well as helping, I guess it helps you to settle knowing that there's recourse later on if there's non-disclosure or they're hiding something.
And then my next question, I guess, to you, Mum, is do you come across some people, and I know we've talked about this a lot in property settlement, particularly with their super. Oh, I'm not going to touch their super. That's like 101 classic. But then there's also the I'm not going to touch the inheritance. I'm not going to touch their personal injuries claim. I'm not going to touch this. I'm not going to touch that. To their detriment, though, where they're trying to be honourable and they want to look like they're the good person, they're doing the right thing. But what do you say to those people when that's the majority of the property pool, and if they don't touch it, they're in trouble?
Yes, I say to them that in spite of the long time since the Family Law Act was written, I still think the way that they deal with property settlement is a fair way. So when I have people who say, and they're being good, I promised him I wouldn't touch his mother's inheritance, wouldn't touch this. I say, well, let's just do the sums the way the court would do it, because that's our benchmark to look across. And then let's look at what you're proposing. And it might be that the difference is so great, and it's for the children as well, that they can't honour that promise. Or it might be that an unscrupulous person on the other side has got those agreements out of you, promised you, you'll just take me for all I've got. And you go, no, I wouldn't do that. I won't touch it. And then having done that, then they proceed to sort of screw you down on the rest of the property. So you really need to put it all in so you can understand what you're giving away, what you're giving back, and what it represents. So when I do the sums, often the total outcome, like I said, because of future needs and contributions balances, is actually the same as giving them all their super or giving them all the inheritance. It's just what you call it. But I always run it through the court system first and have a look at that.
And I've heard some wonderful, you've said it I think in the course and maybe in the podcast as well, some phrasing. So you go, okay, we won't touch your inheritance. Say it was 100,000, but the property pool's 500,000.
Yep.
But, we'll touch all of this instead. So you just find a way to technically not touch it, but you are touching the property pool, but you're just not
that's right.
holding that in. Is that, can you talk us through that again?
So you can say, I'm not touching your super. However, that means you've got greater financial resources going forward. So I need a bigger share of the rest of this property to compensate me for you having that super or you having that big inheritance. I need a greater share. And so instead of, like I said, where it's a 10% range, instead of going to the low ball, you might be wanting to go to the high ball because that's a financial resource to them. Yeah. So we manage it that way. And it doesn't matter what you think, what we call it, my clients and I, or our listeners call it. And it doesn't matter what the other person calls it. If they feel like, and it is a very personal thing, and inheritances, they feel some sort of sacred obligation. But so you say, well, sure, take that. But then my client's going to need 75% of the property pool because she doesn't have that resource or something like that. And they seem to be able to live with that. But we do some nice options depending on personality types. But imagine going through a marriage breakup and
having
your mum's or dad's death as well, that people become very emotional and you have to factor that in and try to make it easier for them to do the right thing by you.
Yeah. And is there anything your parents can do to write in their wills to stop it from being divvied up? Is there any way? I don't know, I put you completely on the line there, but no, there's nothing you can put in a will to stop it from going to their ex?
No, because you'd have to say that at the minute the person's passed away, it is property no matter what it says in the will. If it comes to you, it's property. If they have a clause, this happened in some old English wills, that they would leave money to their daughter provided she didn't marry this person, right? And she'd run off and marry that person. But the will was overturned as being against public policy. Or they'd leave it to their son as long as he divorced that witch that he's been married to for the last 15 years. Again, those clauses chucked out because they're against public policy. So, no, you can't sort of reach out from the grave and direct things, okay?
Wow.
Yeah.
Sounds like a good movie idea.
It would be.
Okay.
Good. But don't forget there's kids a lot in these things, okay? So don't forget there's kids and
what
that
do you mean?
the children will inherit from each of their parents ultimately anyway. So, you know, it's a fair bet that if your ex-partner wants to somehow quarantine his inheritance, say it happened after you separated and there's no way you've made any contribution to it, to that money. In fact, you hated his mum, you know, that sort of thing. Then it will go through to the kids in due course, to his children.
I see what you're saying.
So,
eventually, once your ex passes, it goes to your children anyway.
Yes, that's right. And sometimes that helps people feel better about perhaps not getting about what might seem to be the injustice of another person having a lot more than they have at the end of the marriage. Sometimes, Laura, a death triggers the separation. So I come across this more often than you would think.
That does that. Going through a divorce alone is bad enough, let alone going through a divorce and death, like you've said already. I guess that would be so hard. Is there anything that people should be looking out for, or when it comes to disclosure, how do you disclose these things? Like, how do you say, by the way, I might have a personal injuries claim in the future? How do you put that on a piece of paper? How do you disclose?
It's like that. And
really?
And if you are filling in one of your mediation sheets or the documents of the court, there's always a little box for anything else, and they list the types of things they're looking at. And you can say, oh, yes, you know, or I've signed a contract to sell the business and I'm going to get this much for it over the next 20 years. Or it's just a narrative. It's not a number.
Okay. So I think one of the biggest things I've noticed in what we've discussed about today is everybody's situation is different, because it all comes down to what you contributed before the marriage, what you contributed during, what happened after, then all of these extra lump summy things whether they were early, late, or after. Then add on top of that what your future needs might be.
And you forgot something.
What did I forget?
Your non-financial contributions during the relationship and your contribution as a parent and homemaker as well.
Yes. So all of that in together, and we've got lots of episodes on those, so definitely go listen to them. I'll put them in the show notes, and we talk you through in the course how to nut that number out to get to a percentage. But that's basically, it's a really good idea to go and see a lawyer. Go and see a lawyer.
I notice in our weekly Q&A sessions, there's some of those sorts of questions pop up all the time. Do you notice? Just for anyone who's listening, we do a weekly Q&A for members who've bought our course. Yeah. And that way we sort of, everyone can ask questions online, and we try to answer them. I try to answer them for general education only, but it gives us an idea of, Laura probably for the first time, but it shows me that the same issues are happening as always have, except for the rise, I guess, in separated under one roof, which used to be so rare. And now, unfortunately,
it's like half the people. Half the people are separated under one roof. I think that's going to make for some. We probably should do some more episodes on that. Definitely in the future. So if you're listening today and you think it's totally unfair about this inheritance situation, look, I totally feel you. I think Dick having to give something away that belonged to a loving parent, especially if they didn't like them. But you know, I think, like Mum said, the Family Law Act has been around for a while, not as long as Mum, but it's been around for a while. And they've looked at what's fair, and it's all about setting up everybody on the right path to their new future and not leaving anybody fully in the lurch, basically. It's making sure everyone's going to be able to be financially stable for the next couple of years at least. Is that right?
That's right. And you have the court, by the way, did you say I've been around longer than the Family Law Act or the Family?
No, I said you have been you've been around longer than the Family Law Act, haven't you?
No, the Family, yes, I have, I guess, but I haven't been practicing law since then.
No, I meant your age. I know you said the Family Law Act only came in 1980 something. 75. Okay. Right.
Yeah.
So, and I think the lesson of the story is be honest.
Yeah.
Be honest and deal with the emotional side of having to, but in the end it is money. In the end it's just
money. And sometimes any outcome's better than no outcome. That is, if you are absolutely at loggerheads and all of the stuff we're telling you can't help you get over the line for an agreement, then you are going to have to go in and get somebody you don't know to be a circuit breaker. And as someone wise once said, we need law. We need good laws so that you can try your cases in the court. Otherwise, we're back to hitting each other and fighting over things and that's countries as well. But, law underpins civilization. If you don't have a good rule of law, which is basically just someone who can adjudicate and finish a matter once and for all, then you really are resorting to other behaviours on a global scale, not on an individual scale.
We do not recommend hitting people with sticks, okay? Even though you might want to. Yeah. All right. Thank you, Mum, for explaining that very confusing and sad and tricky time for those people that are listening today. And if you are listening today and you're dealing with a death in your family, we send our love to you and we are sorry for your loss. Sending our love to all of you out there that are going through this, and keep up to date with us. Check us out on TikTok, Instagram, Facebook, and we'd love to have a chat with you. Send us your thoughts. All right, take care, everyone, and thank you, Mum, for your time. If you found this podcast helpful, we'd love it if you could rate, review, and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only, and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording.